Good morning. It's almost hard to believe, but after all these miserable months, and investigations by the score, and doctors by the dozen, and a 9-day inquest, the cause of death has not yet been found of little David Tremblay, the daughter of Liv Bandiera, who was on this program a couple of months ago when she was demanding that an inquest be held to clear her name, after she had, 10 months after the baby's death, been charged with murder and put in Ocala. With me this morning is Liv Bandiera and her lawyer Mike Bolton, and we shall explore how Bandiera feels now and what the prospects are for some equity and justice for this woman after her long, miserable nightmare. Also on the program this morning, to find out about Crown Trust and Day-On Developments and Park Place, is Jim Hewett, the Minister of Consumer and Corporate Affairs for British Columbia. And then we go into some detail on the problems in the shake and shingle mill industry in British Columbia, where last week Forest Industrial Relations asked the IWA for some concessions in shake and shingle mill pay. And to talk about that is Keith Bennett of Forest Industrial Relations. And then, because it's so topical and is going to be a fairly explosive issue, I have prevailed upon Vander Zalm, the Minister of Education, Bill Vander Zalm, to make what we might call a cameo appearance this morning, to see what he's up to this time, demanding that a teacher in Smithers be punished in some way for a sex quiz, when it would appear at the moment that the school board has taken the necessary action and obtained an apology. So Vander Zalm's on the firing line. Once again, I don't want you to think I'm acting as his PR man. I just want to try and get to what this, the nub of what this latest sex survey to 13-year-olds is all about. But first, the Bandiera case, after the break. On April 16, 1981, after Liv Bandiera had hawked her child around a number of doctors in British Columbia, the baby died. The inquest says it can't really find the cause of death, but how do you feel now, Liv, after the inquest and after all these many miserable months of tension after the tragedy?
I feel relieved that it's finally over.
Do you feel really vindicated in every which way?
As much as I possibly could be at this point in time, yes. I mean, the inquest was held 2 years after he died. It may have been a different story if it had been held right away.
How long was it after the baby died that you and Michael were charged with murder?
9 months.
9 months. At that time, were you pregnant?
Yes, I was.
With your baby. And how much time did you spend in Ocala?
A month.
Now,
month and a half.
Month and a half. Have you got over it, do you think?
I think I don't know how much I'll ever get over all this. I'll be able to leave it behind, but...
You'll never really get over it.
No.
Now I want to go to Mike Bolton, Liv's lawyer, and say, are you satisfied with the results of the inquest? Did it, in fact, legally speaking, vindicate Liv and Michael on this kind of indefinite decision by the coroner's jury?
I would say yes, it did, Jack, and for this reason. The jury said that you couldn't categorize this death in terms of its cause. You couldn't tell whether it was homicide, you couldn't tell whether it was disease. In this case, some prosecutors decided that this was a case of homicide. There was no coroner's inquest, and they went ahead and prosecuted Liv and jailed her. In fact, if the Coroner's Act had been fully followed to a T, and this inquest had been held within a few weeks after David Tremblay's death, I'm confident that the result would have been the same, and Liv Bandiera wouldn't have gone through these criminal proceedings.
All right, what were the faults that were shown, the obvious faults that were shown and reported in public on the way in which the death of David was handled?
There were several primary failures, both in the medical system and in the legal system. Firstly, in the medical system, diagnostic testing of David Tremblay during his life was not done. He was in fact sent to Vancouver General Hospital by a pediatrician in Comox for the purpose of having factor assays done of his blood. Those would have determined whether he had a bleeding disorder, which appeared to Liv to be the case, and appeared to many other people to be the case. For some reason, the pediatrician's consult did not ever reach Vancouver General Hospital.
What do you mean consult?
It was a written consult by the pediatrician setting out his diagnoses of what happened to David, and was sent to Vancouver General Hospital to accompany the infant in an emergency air ambulance. For some reason, it never got there. When VGH received the boy, they didn't know what to do with him. They discharged him after a day and a half because there was no indication of anything else that needed to be done.
Just from your memory, Liv, at that time, how many doctors had seen David?
At that point in time, he had been seen by 5 doctors.
Did anyone ever mention to you, if this is a fair question, Mike, did anyone ever mention to you the suspicions that arose apparently in the minds of some of the witnesses in the inquest that that they feared some form of child abuse?
No.
Did no doctor ever say to you, has this child been beaten?
They asked me if he might have been playing rough with some other kids. Not all of them.
Were there suggestions at the inquest that there might have been child abuse?
Well, there were several doctors who, after the fact, who came forward and suggested that this could have been a case of child abuse. The problem from that point of view is that they were working with autopsy evidence that in the first instance was inadequate and did not support any of the conclusions that they were drawing from it. The jury, I think, understood that.
Isn't there a legal obligation for anyone in an official capacity who suspects child abuse so to report it?
If doctors had suspected child abuse, they should have reported it. The Protection of Children legislation protects doctors from any action, any civil action, if they make a mistake in reporting child abuse. There's nothing to deter them from reporting it. If they had suspected it, I'm sure they would have reported it.
Mm-hmm. Now, I don't want to inhibit your possibility of legal action in any way, but let's go over the jury's recommendations first of all, which are perhaps the best way to demonstrate what appears to be mishandling of an investigation after a death which was not identified the cause at the time. What were the mistakes made?
Well, the jury clearly identified the failure of forwarding of information along with the patient to Vancouver General Hospital. The jury also identified a lack of autopsy evidence. The jury, in fact, recommended that a standardized protocol or procedure be established for autopsies by pathologists in cases of questionable death. Those recommendations, to my mind, established that the jury accepted the evidence that we brought before them and the evidence that we tried to expose at the inquest, which was that the proper procedures just weren't followed in this case. Mm-hmm. What happened was a very inadequate autopsy, followed by a very inadequate police investigation, followed by the laying of criminal charges by Crown Counsel, who obviously had not reviewed the matter with sufficient thoroughness.
How many months was it before where were you that day when they came to you and said they were going to charge you with murder?
I wasn't home.
And you were home and somebody walked in and said?
6 police officers, yes.
How many police officers?
6.
6 police officers. And the 2 of you were arrested and taken forthwith to?
I was there by myself.
How long were you in jail?
A month and a half.
Month and a half in jail. How did you get out? Who raised the bail?
Neighbors on Cortes Island.
Who have stood by all through these troubled months?
All the way down the line, yes.
Am I right in recalling that the amount of sureties raised by your neighbors was $125,000 in property?
It was, I think it was, yes, $125,000.
And how long after you got out of Ocala was it they told you no charge?
I got out of Ocala mid-March, and that was August.
March, April, May, June, July, August. That was strange, wasn't it?
What does that indicate?
What does that indicate to you, if you can tell me, as I say, without inhibiting yourself?
The charges were laid 9 months after the boy's death. Obviously, an inquest should have been held in the meantime. The charges were stayed another 8 or 9 months after they were laid. They were stayed because senior Crown Counsel reviewed the file and decided the evidence didn't support the charges.
In other words, I can make, as a member of the public, I can make the layman's decision that when somebody finally reviewed the charges, he thought, uh-oh, we don't have enough to go to a preliminary hearing for a committal on murder charges.
That is precisely what occurred. A potential embarrassment was averted by dropping the charges, by staying the proceedings.
One of the problems being that you were so far away on Cortes Island, you were lucky you had your friends around, were you not?
Mm-hmm.
More with Liv Bandiera and Mike Bolton, a lawyer, after the break. It was after Liv Bandiera and Susan Robertson were on the program a few months back when Liv was saying, must have an inquest, must be vindicated. Why has there not been an inquest? Why wasn't there an inquest on the death of the baby in the first place, Mike Bolton?
That's a failure of compliance with the Coroners Act. The Coroners Act provides that in case of a questionable death, whether by homicide, medical malpractice, negligence, or some other cause, there must be an inquest. The only exception to that is where criminal charges are actually laid. In this case, no criminal charges.
Oh, the hiatus therefore was because of the police suspicions that there might be a homicide charge here, so during all that period, no steps were taken to have an inquest.
That is correct, Jack. 9 months went by, the police had their suspicions, the police conducted their investigation, no charges existed, and no inquest was held.
But surely at least what should have been done was that there should have been the start of an inquest, perhaps the pathology organized all the way through, and then adjourned during the investigation.
The failure of pathological evidence, which the jury needed to arrive at a conclusion, would never have occurred if the coroner's office had gotten involved right at the time that the death occurred.
One technical question, and you will forgive this question, Liv, I want to put it to Mike Bolton. Was there not some evidence of a traumatic experience of the child from some of the remnants of the pathology still usable?
There was evidence which could point to trauma, and there was evidence which could conceivably, in an appropriate case, have pointed to abuse. But there was a lot of evidence that pointed in other directions, and much of it was lost by the manner in which the pathology was conducted.
And of course, there never were any blows struck at the child.
No, never.
Neither by you nor Michael.
Never.
I always remember after we did the program, I got a whole flood of calls about purpura. Purpura, the mysterious bruises that appeared and disappeared and still do, especially in children, and can sometimes be fatal. Was that ever investigated at the inquest? The cause of some other blood disease, which I understand if that goes to the brain can be fatal.
There were several blood diseases that were investigated at the inquest. For example, a disease called von Willebrand's disease, a bleeding of the blood vessels. There was a disease called Henoch-Schönlein purpura, purpura fulminans. I'm just getting the grasp of all these terms now, but there were several different kinds of purpura, which is a bruising illness, and evidence.
Because the bruises used to appear and reappear and disappear, did they not?
That's right.
As I recall. Was that ever properly, was it possible clinically to check that out with complete definition in the inquest?
There's where the failure of the diagnostic testing to be done at Vancouver General Hospital comes into play, because if the boy had been given the tests that were ordered at Vancouver General Hospital, then we might know the answer to those questions. At this stage, there's no way that the coroner's jury could do more than return a verdict of cause undetermined with the evidence.
When you were on my program the last time, you told me that a police officer said, or was it to Mrs. Robertson, the police officer said something very heavy. Do you remember what it was?
That he was going to keep coming around and around?
And that this was a murder investigation.
Yes. Yeah,
and
he
they
said
would
that.
keep coming around and around and around until they'd solved it. Did that policeman give evidence to the witness stand?
Peculiarly, he did not. We didn't really understand why he wasn't called, and we were, in fact, looking forward to having an opportunity to cross-examine him about the manner in which this investigation was conducted. But neither he nor the prosecutors who laid the charges were called as witnesses at the inquest.
And they could have been, presumably.
They could have been.
Now, money. Last time you were here, you were still stuck with the legal bill which was coming down. You'd paid off $7,500 in earlier legal bills?
10,000.
10,000.
Yes.
So where did you get that money?
That was raised on Cortes Island.
By your friends in Cortes
Yeah.
Island. And then you still had a balance of legal bills from your previous lawyers.
Yes, I did. I still do.
How much?
7,500, owing more than that actually, almost 9,000.
Still owing.
Yes.
Now,
previous
what about
legal bills.
One can't ask about Mr. Bolton's fees, but you're going to have to pay them. Somebody's going to have to pay them in due course. Is that not correct?
Yes.
What remedies on the face of it does Liv Bandiera and Michael, what's his last name?
Bolton.
Bolton, no,
Scott.
Scott. What do they have any remedies at law? After all, I could be charged with a criminal charge tomorrow. I could be acquitted after $25,000, and technically speaking, I have no right for any reimbursement from the Crown. Is that correct?
Technically speaking, the Crown has no obligation to reimburse you for anything. However, there are remedies under the malicious prosecution and false imprisonment avenues. The problem with malicious prosecution is that one would have to show that the RCMP officers who did this investigation, or the Crown who laid the charges, acted with actual malice. Now, that kind of bad faith is difficult to prove, particularly where the police are involved, because they have an excuse that they are doing their duty.
Even if they do it badly or make a mistake, they are entitled to believe they're doing their duty without malice.
That crystallizes the state of the law.
Right.
False imprisonment is not requiring quite so heavy an onus on the plaintiff. False imprisonment is a matter of showing that you were imprisoned and without proper evidence. In my view, the inquest verdict, deciding that the cause of death is in fact undetermined, and deciding that it cannot be classified as homicide based on the evidence available, is a verdict that gives us a good footing for an action for wrongful imprisonment. So I'm hopeful that that's one of the remedies. Another remedy that we want to look at is the fact that the nervous shock that Liv Bandiera has suffered, the emotional and physical strain that she's underwent, arising from the fact that there was an improper autopsy protocol done in this case. We feel if the autopsy had been more complete, that may have avoided some of the problems that occurred, namely the laying of criminal charges. Now that is a complicated thing to look at, but that's one of the avenues of legal remedy that we're looking at.
So false imprisonment is a possibility. Malicious prosecution is a lesser possibility. But is this not a case, and I'm grinding your axe or grinding Liv's axe for her, where if there are no legal remedies in court at law, that in all fairness, the Attorney General should make an ex gratia payment for the amount of monies which Liv owes as of this moment?
That would be a very minimum contribution by the Attorney General. In my view, the case requires that. The criminal justice system in this province requires that the Attorney General do something like that in order to vindicate itself for the actions taken against her without proper evidence.
Couldn't do it in all the cases, of course, because if you opened that Pandora's box, everybody who was acquitted for anything, even on reasonable grounds, would want their money back. But in this case, am I correct in saying, one, that no evidence appeared during this inquest to point a finger at Liv Bandiera or Michael Scott?
I say that the jury's verdict shows that there was never any evidence.
How do you feel, Liv?
Pretty tired.
Still a bit stunned?
Yes.
Are you going to stay in Cortes Island?
Yeah, I'm planning to.
Planning to stay in Cortes Island? With your friends who have proven their worth to you by the sureties and the contributions and the support they gave you throughout?
Yeah, with my friends.
How many doctors did you take David to? Just
8 doctors.
8 doctors. From doctor to doctor to doctor to doctor, right? Mm-hmm. Quite incredible, isn't it? Did any of the... Is it fair to ask this question? These doctors, of course, most of them probably testified under the Protection of the Canada Evidence Act.
Every doctor that treated David Tremblay testified under the protection of the BC and Canada Evidence Act.
That is normal procedure for a doctor who might in some way face a possible action later on.
That is correct.
So what's your next step, Michael Bolton, lawyer for Liv Bandiera?
Well, we're looking at all the possible remedies right now, and I'm sure that some remedy is going to be sought. We also will be in communication with the Attorney General of this province to try and seek some redress from him, and in the hopes that we can avoid further economic hardship for Liv and also further strain and stress of legal proceedings.
The only place we'll ever get to the real root cause of it will be, however, in the course of any court action, because it's unlikely the Attorney General is going to open his books and his files to you on this, isn't it?
I think it's unlikely based on my experience with these kinds of cases.
What are you going to do now, Liv?
I think I'm going to get some rest.
Back to Cortes?
Yeah, go home.
Today. My thanks to you, Michael Bolton, and to you, Liv Bandiera. Let's hope the nightmare is over for
Yes.
once and for all. Next.
Thanks.
Vander Zalm here yet? No. Jim Hewett, Minister of Consumer and Corporate Affairs on the Crown Trust Nest. After the break. It would seem that trust companies, at least one, are the soft underbelly of financial institutions in Canada. And I don't think the financial system has had such a black mark as the complicated mess which arose in Ontario when these other two trust companies moved in and sold a whole bunch of apartment blocks reputedly to Saudi Arabians. With me this morning is Jim Hewett, who is the Minister of Consumer and Corporate Affairs in British Columbia, responsible for the trust company legislation. And what brings you to, puts you in focus this morning, Jim, is the fact that all of a sudden, here we've got Dayon Developments who are in bad enough trouble as it is, suddenly having to close down 230 jobs on potentially the biggest office building in Vancouver because of a mess in Ontario. Can you put these 230 men back to work at Dayon Developments without giving away the farm and without totally protecting the investors in Crown Trust?
Well, Jack, Dayon's caught as a separate part of the Crown Trust problem. Crown Trust had its first mortgage with Dayon Development with Park Place Towers and wished to move into a second position. And accordingly, the Bank of Montreal asked us for an order in council which really moves Crown Trust to a second position. And that's where Dayon's involved. It's tied up in this Crown Trust fiasco, is really what it is.
So if we leave the Crown Trust fiasco to the side, the situation was that Crown and Dayon were 50-50 partners in this massive office building, right?
Yes, yes.
And Crown had committed itself to a $50 million first mortgage.
That's correct.
And where did the bank come in?
Well, what you've said isn't irregular. That happens from time to time with development companies and with the institution that's going to put the mortgage on it. Since last fall, as I understand it, as the information I have states, they were looking and have been discussing and negotiating with a first mortgage or with additional financing to come into the picture, because I believe the building, the Park Place Tower, total financing would be somewhere in the vicinity of $125 to $150 million. So the $50 million first isn't going to solve the problem. So they were negotiating, and however that financing would be arranged, in normal circumstances would have been all right and things would have gone smoothly, but Crown Trust in Ontario
closed the books, seized the thing.
Ontario moved in, and that tied up Dayon into that whole problem.
Tell you why I wanted to investigate that a little more for my satisfaction was, here you have Crown Trust and you've got Dayon, and they've got $50 million up as a first mortgage at that stage, right? Was it legal and proper for them to apparently decide in advance to put the $50 million into a second mortgage position and bring in the Bank of Montreal with a $100 million first mortgage?
Well, the way they have done it and the way they've involved us, it requires us, and we've been requested to put the order in council through. But there are two acts that they work under. One is the Trust Company Act and the other is the Trustee Act. And if I wouldn't want to bore you with the technicalities, nor do I fully understand them, but I don't believe that there's any, quote, unlawful act that was done either by Crown Trust or by Dayon. The problem is that the owners of Crown Trust and the Ontario government got into difficulty, and Ontario government moved in, seized the assets, and then of course we have to be responsible for the depositors of Crown Trust branches in British Columbia.
What I was getting at was I never thought that trust companies were allowed to be into the second mortgage position at any time, because just imagine if some of the trust companies, some of the smaller ones, had been second mortgaging during what you might call the Scalbania era. Goodness gracious me, if they'd gone big on second mortgages, more than one would be belly up now.
Well, they can be in second mortgages. Under the Trustees Act, there are several sections that allow them to do certain things, and also there are limitations on how much money they can put in certain
25% of their paid-up capital.
And in that particular case, there could be some question as to whether or not they exceeded that authority, and that's the legal aspect of it.
Now, then we come to the one question. The BC government and Jim Hewett have the power to put 236 men back to work by saying to Dayon and Crown, okay, your $50 million can go second, the Bank of Montreal will go first. When will you make that decision?
Well, we're, from a legal point of view, and I've got a whole battery of lawyers from the AG's
I
department
can believe it.
and my ministry trying to
I hope they
determine
know what they're
the
doing.
ramifications. But one thing, the government is not, quote, bailing out a Dayon, and that's unfortunate statements have been made, I think, in the past few weeks. But what we have to ensure, first of all, was that the depositors of Crown were protected. That's taken care of. As of today, I believe Crown Trust depositors are Central Trust Company depositors. That's taken care of. Question is, will or could the Order in Council be struck down at a later date through legal action because Ontario didn't have the right to do certain things and therefore BC didn't have the right to pass the Order in Council? We have to be assured that legally we are correct in passing that Order in Council, and that's what's taken the time. I'm hopeful that that'll be resolved very quickly, very shortly this week.
Like this week?
I hope so.
So Central Trust have moved in and they've bailed out the depositors. They've bought the hard assets of Crown Trust.
The good assets.
The good assets of Crown Trust. So they're going to, if I want my 20,000 or my 50,000 or my 100,000 out of Crown Trust, whether I'm in BC or not, now I can get it out.
The Canadian Deposit Insurance Corporation, in working with the Government of Ontario and selling those good assets to Central Trust, has in effect lifted the restriction of $20,000 per account, and anybody who has an account, as I understand the information I had last Friday, anybody who has an account with Crown Trust, now Central Trust, in British Columbia, can withdraw any part or all of their deposit.
But you've got another statutory obligation, and is it correct that your superintendent of trust companies has told you that the affairs of Crown Trust are not in order?
Yes, basically he has to report to the minister any irregularities, and of course he has been informed of the problem of Crown Trust since early January when all this was taking place, and I have a report from him. But those problems that he identifies are being, you might say, eliminated one by one with the Ontario government passing their legislation, with CDIC coming in. What we have now really is for the government of British Columbia to ensure that we don't put at risk the taxpayer of British Columbia by taking an action which could be struck down at a later date. And I hope that the legal advisors that we have will in effect give us that opinion and will move.
So therefore you will not be, quote, bailing out Crown. After you get your legal advice, hopefully this week, you will decide whether or not you can pass an order in council putting the Crown Trust into a second position and letting the work start if the Bank of Montreal still puts up its $100 million.
Well, that's between the Bank of Montreal, of course, and Dayon. But the other thing is, once the depositors move from Crown Trust to Central Trust, the question I asked, and of course I haven't got a legal opinion on it yet, the question I asked was, do they need to come to us anyway? Now the depositors are taken care of, and our regulatory responsibilities is to ensure depositors' money is protected, and once they move to another trust company, is it necessary that a company comes to us to say, we want you to approve a second mortgage position? And these things are ongoing developments that have been happening over the last
Oh,
week.
you're saying if Central Trust has in effect taken over the usable assets of this company, the Ontario government's regulations could apply?
Well, the depositors are protected. CDIC says you can have your money.
Anyway, Jack Poole's got to hang on the ropes for another week or so to get a firm decision from you as regards to the second mortgage.
Yeah, and I think it's fair to say that I and I'm sure my colleagues don't want to see any job in downtown Vancouver, anywhere in British Columbia, shut down. We'd like to see those people at work.
More with Jim Hewett. You might have some questions on trust companies. Yeah, we've time for a phone segment. After the break. Consumer and Corporate Affairs again. Any other trouble at the moment, Mr. Hewett?
Nothing that I know of other than I'm still the minister responsible for ICBC, and that gets me in trouble from time to time.
You shouldn't have mentioned that. You should not have mentioned ICBC. Go ahead, please, to Jim Hewett.
Yes, Jack. The minister also has responsibility for the Liquor Control and Licensing Act, and I have a question with respect to the branch. And I've sent the telex on November the 24th, and he has not yet responded.
Get to the point. What's the question?
Basically is this, that an applicant had conducted a referendum in an area for a pub license, and the general manager refused to accept the results of the referendum, and the referendum achieved a 64.35% approval vote from the community.
Well, can't you go over his head?
You appeal.
we're asking to meet with the minister, and we've been asking since November the 24th. And this is the first opportunity I've had to speak to him, and I'm wondering if it's possible to have an informal meeting, or secondly, does a general manager have the powers to overrule a duly constituted, conducted, and ministerially approved referendum?
Take the second question.
I can't really respond in regards to the overruling aspect of it, but you have the right of appeal.
Yes.
Did you go that route?
Yes, we have the right of appeal, but your deputy minister is going to allow the appeal, but we first must waive the right of further appeal should she bring down a decision not in the applicant's favor. And that's like going before a judge and the judge saying, well, if I go against your case, you're not allowed to appeal it.
I see. Well, you're talking to me on a particular application of which we have several hundred coming in.
No,
I think the best thing to do is to,
he has
to
a
provide
lawyer.
me with the information.
He has a lawyer. We'll take his phone number and you might get something
Sure.
to call him, Jimmy. But I don't like fighting private battles for a guy who wants to make $1 million in a pub on the air. My basic Presbyterianism comes through. Where am I going? Go ahead, please.
Yes, Jack. I just wanted to have a word about this day-on type thing. We're looking at a situation here whereby everybody is saying that the people at Crown Trust are being well protected and that the jobs are important. What we've got to realize is that those jobs will go ahead even if Dayon and Crown Trust go bankrupt out of this deal and somebody else picks it up at a cheap price and then hires people and goes ahead and builds it, which is what will happen. So the jobs really don't enter into the picture. The situation is this, that we have here is a classic Oklahoma offer on this property whereby the Crown Trust has a perfectly good $50 million first, which totally protects the investors, which is going to be subordinated in favor of a second position at a value which is more than the current value of the total building. The payments on $150 million at current rates are going to run, they've got 580,000 square feet of rentable space. Their income is $25 a square foot, which is higher than the going rate of $20 in the downtown, is going to bring them in around $17 million, a net of around $10 million. Their payments are $22 million. That's a $12 million shortfall. I can't see where the people at Crown are not being put at risk for the simple reason that if I were to come to you and say, Jack, I'll buy you Salt Spring property, I'll give you $100,000, I'll give you $50,000 down, only I want you to take a $50,000 mortgage, but I want you to subordinate it to a second so I can get a first to get the money to pay you in the first place. I then go out and get somebody to give me $100,000 first. I give you $50,000. I put $50,000 into the bank of HIP, which is on my pocket here. And then I turn around and if I can't meet the payments, I turn around and I go bankrupt or I back out of the deal.
Okay, your point is clear.
Property back, and you're out $50,000 because you've now got a $100,000 mortgage and you only got $50,000. And that is what's happening here. This is, if I would, the Bank of Montreal and Crown Trust are paying this money out on a very bad loan. In fact, if you were to go to the marketplace today, you might not get $100 million for that property. It's being done because they want to keep Dayon current with their current debt. It's like lending money to a lesser developed country to pay interest because they don't want to declare bankruptcy because the stack of cards would come down because the money that they owe the chartered banks is huge and the assets they have don't cover any part of it, any major part of it.
You're saying leave it to the free market and if it goes belly up, somebody will pick it up. That's what you're saying.
Exactly.
Mr. Hewett, are you considering that aspect?
Well, that's a possibility, but I think it's fair to say that we are aware that studies have been done by Woods Gordon which indicates that the building as it is right now would not give protection to the first, and the best or lesser of two evils, if you would be to go to a second position, have the building completed, have it generate revenue, and have a cash flow coming in. So
A negative cash flow, huge negative cash flow.
I could give you the statistics, but again,
I
all that's
worked them
being
all
worked out.
I know the business.
All that's,
you can't convince me. If I had my money in the Bank of Montreal or Crown Trust, I'd take it out because those are bad loans.
but that's
made
not
for a bad purpose.
That's not our role. Our role is basically to protect the depositors, and our role is to, as a regulatory body, is to ensure that there is no loss by the depositor in British Columbia. Whether it's a bad loan or good, that's up for the businessman, up to the banker, to the lender to determine. I'm just saying the business case is being presented by a capable, creditable accounting, auditing firm, they indicate, and the Ontario government has accepted that, as the province in which that company is registered, that the best business case is to move to a second to allow the building to be completed.
Thank you. Go ahead, please.
Good morning.
Morning.
I've heard something about a different trust company. Now, it's not Crown, it's Royal Trust. First of all, I've got maybe 2 or 3 questions. Is Royal Trust going into receivership?
Oh, here we go again.
Not to my knowledge. I couldn't answer whether they're going into receivership or not. We have the regulatory responsibility.
Let me
under the
take
Act.
this. I'm not about to take calls on the air which throw unsubstantiated problems, worries, and fears. Please don't do that again to me, listener. If you think somebody's going to go belly up, tell the minister or tell me off the air.
Okay.
You might say next yesterday, is Webster going to do a Scalbania and file a personal bankruptcy or make a deal with the income tax department?
Okay.
And I couldn't defend myself except by saying 3 days later, no, it's not true.
Fair enough.
Fair enough. Go ahead from Vernon.
Good morning. I was wondering whether you hear all this about Crown Trust being bought out so that the investors are going to be paid back, but we are invested with Greymac, and we don't know just what the relationship is, whether when they say they bought Crown Trust, whether that covers Greymac as well, because we're $3,400 short of our investment. We signed the waiver and we got $20,000 back, but we didn't. They deducted the interest, so we're out $3,400, and we're wondering whether we'll ever get that back.
Can you answer that one, Jimmy?
I can't answer that with regards to Greymac. We're dealing with Crown Trust, who has operations in British Columbia, and the limit of $20,000 was put on there for depositors. And then, of course, because of the sale of Crown Trust's assets in Ontario, the Canadian Deposit Insurance Company has lifted that limitation to $20,000 because now those depositors will be with Central Trust. Greymac and the other trust company are Ontario Trust Companies.
They are covered by the CDIC on the deposit thing. That I'm
well,
sure.
the lady indicates that she received $20,000 and
But
signed a waiver.
She lost $3,400 interest. Thank you, man. The best we can do. I'm going to replace you with your cabinet colleague, Mr. Vander Zalm. I'm sorry about that. But when will we get the decision? And when do you think that Poole and Deon and Crown will get the decision?
Well, we, as of last Friday, there were 1 or 2 legal aspects that we were trying to resolve. The business case, I think, has been resolved. The point that I just would like to make is that, quote, the BC government is not bailing out Deon. We are just fulfilling our role as a regulatory body under my ministry, and that we have to do.
And you don't think anything improper or illegal has been done at all, according to
Well, that's for the legal side of government to determine, but the indications are from Ontario. There are charges, I think, with regards to shareholders, but not as far as the running of the business. That Crown Trust Company was an 88-year-old trust company.
My thanks to Jim Hewett. Next, Bill Vander Zalm in trouble again after the break. This is the questionnaire used to grade 8, I presume, 13-year-old students in the school system in Smithers, which has caused Mr. Vander Zalm to demand, I think it is, that the teacher who used this in the classroom should be punished. Is that correct, Bill?
That's correct.
Now, before we get into the questionnaire, if we dare talk about it in any detail at all, has the school board not told you this teacher has already been reprimanded?
Well, I didn't hear from the school board, of course. I first heard from the parents in the area, and I immediately set out to take the action that is outlined in the papers, where I've said, okay, you know, the school board should suspend the teacher for a time without pay. As an example, I believe, to teachers elsewhere, although, mind you, I'm hoping and trust this is a very isolated incident, but I think we need to take some action to just make it very clear that we'll not put up with this sort of garbage in our schools for 13-year-old kids.
Was this, was this questionnaire given to each child in class?
It's a part of the guidance course, apparently, which, of course, in some areas could involve sex education, and sex education can have a considerable range as to what's involved or what's provided by way of instructions and questions. Although I don't believe anything like this has ever been done anywhere, at least not to my knowledge. That's so far out and so vulgar and immoral, I've never seen anything like it.
This is done by a consultant, says here, Amy Napier-Hemi, for the Human Resources Department in 1971.
Well, that could well be. I don't know. That's what the paper says. I'm not aware of it being in the files of Human Resources, but I would recommend Human Resources go through their files and find out what sort of garbage they've got in the system, but it's certainly not been released to 12 and 13-year-old kids.
Some of the questions are really quite grossly obscene.
Yeah, I just don't want to read them out on the air here, Jack. If you want to take the responsibility for that, be my guest, but I don't want any part of that, no.
Some of the questions about homosexuality are particularly odd, to say the least, and sexual measurements. It's a tasteless, in many ways. Some of the stuff is acceptable for a teacher's material for sex education, is it not?
Well, some of it, yes, but if a good many of those questions were read out on BCTV, you might lose your license.
Well, I wouldn't read them. Wouldn't read any of them out on BCTV. In fact, there are sexual references here even I don't understand in the slightest. Well, now, where's the chairman of the school board? Carol Johnson. Where are we? Which line? 1244. Miss Carol Johnson, chairman of Smithers School Board.
Good morning, Jack.
I have the minister here, and can you please tell me what punishment, if any, this teacher has had?
We hadn't given any punishment because we hadn't made a final decision with the board yet. The board is meeting tonight, and hopefully we'll tie up the last ends of this matter.
But was some action not taken? Did I not see somewhere that after it was drawn to your attention that the teacher apologized?
Oh, yes, the teacher has apologized, the principal has apologized, and we as a board have apologized. We no way support or condone the questionnaire in question. We've also had a regular board meeting with several parents. We've had 2 public meetings that involved about 100 parents at one meeting, another 200 at another meeting. There's been several smaller meetings with parents. We've put a public apology in the paper, and we have been still investigating the matter to see exactly what we would do. And our last meeting, hopefully to tie it up, will be tonight.
These children were 13-year-olds?
That's right.
Boys and girls?
Yes, I think a different questionnaire went out to each, but along the same lines.
Well, how in the name of goodness did it get into the teacher's hands in this form?
The teacher had been given it at a seminar that was put on by the college here. The material originated from the Human Resources Department.
Was it meant for schools, though?
It was meant, yes, it was to prepare the teacher in case she was asked these questions by anyone in the class.
Well,
she in turn handed it out in good faith to the students, thinking that they were ready for it. But of course, that was a lack of judgment on her part.
Oh, a young teacher or an old teacher?
Fairly young, I would think.
In her 20s?
I would think she's in her 20s. I'm not exactly sure. 28, 29 maybe?
Mr. Vander Zalm, here's the teacher who says the chairman of the board, Carol Johnson, have apologized all over the lot. They've realized it was a bad mistake. They've apologized in the newspapers, the principal, the teachers, the school board. Is that enough for you, Mr. Vander Zalm?
Well, I'm asking, and I've asked the Smithers Board for a report on this, Carol, and certainly I look forward to receiving that report because the information that I've been getting from the parents, by way of letters largely, but phone calls.
How did you get the information?
Well, through the parents. I've had...
If I might interrupt, we've sent a complete package to your office that was received on January the 20th. Now, in the province of yesterday afternoon, they make reference to a letter that has been sent to me by you. I have seen no letter.
In his letter to the Smithers School Board, Vander Zalm says.
Yes, I've seen no letter. I see the reference to that letter, but I have
while
not
he reads
received
it
a
out.
letter.
Words cannot express my revulsion towards this incident. The teacher should be suspended without pay for a reasonable period of time. This is what I've put in the letter. The letter only went out, I admit, a few days back, and we had only heard from the parents in the area, and certainly the indications were that when the parents brought it to the attention of the school, that in fact they were told, look, you're way out of line, you're just not with it, this is 1983 sort of thing. Now, I'm not able to quote word for word what the letters contained, but words to that effect.
What is your opinion of this material, Mr. Vander Zalm?
Oh, I think it's horrible. I shudder to think that it's even anywhere on file or that perhaps a principal someplace might circulate this sort of material to teachers or whomever. It's terrible stuff.
Will you go through the...
Red Hot Video wouldn't get away with this sort of garbage.
And are you going to go through the school board files and remove all the stuff which refers in detail to how a pretty vulgar teenager might refer to sexual activities?
Well, you know, the trouble is we obviously have an attempt elsewhere throughout various school districts to bring in guidance courses which involve some sex education. This destroys any chance of providing even a minimal of information to students because parents rightly will become terribly upset when they see this sort of thing.
You mean if a 13-year-old brings us home to Mommy and Daddy and says, hey, Mommy and Daddy, what's this all about?
Oh, well, I'm surprised. I'm sure if it happened in my community, now maybe Surrey is a little more square, so to speak, I'm not sure. But if that happened there, they'd have a revolution at the school.
Well, didn't they, Mrs. Johnson, didn't you know this material was being used in the school?
We didn't know that particular questionnaire was going to be used.
How long has it been used in the school?
This is the only time it's been used.
Just on one occasion?
Indeed, it'll be the last time.
Well, Mr. Vander Zalm, why don't you go up to Smithers and put them in their place?
I will do one day soon, Jack, but I certainly feel that we have to make it very clear to school districts, principals, teachers, anyone and everyone involved in the system that we cannot put up with this sort of thing. And I think Carol understands, and I'm sure that we'll get an explanation, and I hope that they'll take the sort of measures in Smithers that will at least demonstrate clearly to everyone in the province that we won't put up with
You
this.
still think the teacher should be suspended without pay as a punishment?
I believe so.
Carol, is that a consideration for your board?
That'll be for the board to decide tonight. I don't even want to discuss what all the considerations would be at that meeting.
My thanks to Carol Johnson, Smithers chairman, and to This Is Worse Than Red Hot. Some of it's pretty gruesome.
It's terrible.
Grossly obscene, some of it.
Grossly obscene, and that's putting it mildly.
As you said, worse than Red Hot video. Well, not really, but
Well,
for 13-year-old kids.
I tell you, I couldn't read it to a meeting of adults, let alone give it to a 13-year-old youngster.
My thanks to Bill Vander Zalm. Next, and at last, Keith Bennett of FIR on a nice, good, square topic, the problems in the shake and shingle industry, after the break. It's many years since outside of an IWA Forest Industrial Relations strike or possible strike or contract negotiations that I've seen such an interest in one specific section of the forest products industry in British Columbia. And it all begins, I suppose, with Green River Log Sales and Scott Cedar Product, when a week or so ago, the owners of these mills said, the IWA won't play ball, they won't work for $2.63 an hour. They want the 1982 rates of $3.03 plus the standby, so we're going to close down the mills. Last week, Keith Bennett took certain action with the IWA, in which I say you got snubbed. Could you tell me what happened?
Well, Jack, the problem that you referred to at Green River and Scott Cedar, of course, is just a indication of a much bigger problem, and the bigger problem is for the whole shake and shingle industry. And we met as a group, that is the people in the industry met, and they asked me to make one final approach to the IWA to consider the reduction of the piecework rates in the shake and shingle industry. And I met with the IWA, I put the question to them, and the answer was no. They would not consider it.
Because is it not a fact that what you were doing was really the unforgivable from a regional point of view, and saying to the IWA, I want you to reopen the contract that we negotiated with you almost 2 years ago now and cut the rates.
That's exactly what we're asking them to do. Now, we're not asking them to cut the hourly rates. That is the rates of the boom men and the filers and the tradesmen. We're only talking about a reduction in the piecework rate. And piecework rates have moved up outside of the contract in the past. The market got particularly hot. The crews used to go to the owner of the operation and say, we want an increase, and in many cases got one. So it's an adjustment in the piecework rate. It is not a rollback or a major concession by the union.
All right, now let me get that straight. If I'm working in a shake or a shingle mill, and I'm a tradesman, have I been getting paid the 1982 contract rates all the way through? A tradesman other than what do you call the guys who do the shakes and shingles? Kuberman and...
Kuberman or resawyers.
Or packers.
Or packers. The pieceworkers are the ones we're talking about. A tradesman would be getting the standard 1982 industry trades rate.
But you said to them, are you prepared to drop down your piecework rate so that we can keep these mills open, paying the other guys the full 82 rate?
Exactly.
It is a form of rollback, Keith. I mean, all nonsense aside, or all delicacies aside, it is, you're asking for a rollback on piecework rates.
That's what we're asking for. It's, I think if you compare the industry today to the industry 10 years ago, you can see what's happening to the unionized mills. Within our organization, 10 years ago, we had 27 shake and shingle operations employing 2,000 people. Last week, the member companies of ours that were operating numbered 6 and employed 390 people. In the meantime, the non-union mills have blossomed to the point where there are 20-some-odd non-union mills employing over 1,000 people. Now that's the problem that the unionized mills are having. They can't afford to pay the negotiated rates in what is a very poor market now and compete with the non-union mills, who can pay their people anything they want to pay them.
You've gone down from 27 unionized shake and shingle mills involving 2,000 people to 6 involving less than 400.
To 6 operating last week.
6 operating last week.
Right.
Now, some of those are what you might call very efficient, almost integrated mill operations, are they not?
Yes, they are. Normally, and I don't know why this is, but the unionized mills are much more efficient. They're better mills. They have better equipment. They have better facilities for their employees. Generally, are much better mills. And they pay higher wages, and they provide better benefits. You should see some of these non-union lean-tos that they've got out in the river out there. They're a disgrace. But our people can't compete with them.
In other words, guys can go out with their non-union lean-tos, slap up a Jippo mill, and get in on the gravy on the market and cut the prices of the union-run operations.
Sure. The average Cuberman in the unionized operations can make anywhere from $170, and in one case I think got up to $300, but $170 to $200 and some odd dollars is the average wage for a Cuberman in the unionized mill. These non-union mills are paying somewhere in the area of $100 to $115. Plus the fact that the unionized mills have to provide all of the negotiated benefits, the medical care, the dental care, the extended health benefits, and the life insurance, and all the rest of that. These non-union mills are under no obligation to do that. I believe some of them do, but they're nowhere near the benefits that the IWA have.
If a guy gets laid off in Scott Cedar or Green River Log Sales when they closed them down last week after that particular rumpus and goes to work in a non-union mill, is he still covered by his IWA health and welfare package?
Yes, the collective agreement with the IWA says that we must provide up to 6 months layoff coverage. And the medical coverage amounts to $100 per month. So that's $600 that the unionized mill has to lay out for someone they lay off. Now these people then go to work in the non-union mill. The first question they're asked is, how much layoff coverage do you have from the unionized mill? And the fellow will say, well, I have 5 months left. Fine. Then we won't cover you with anything for 5 months. So the unionized mill's paying his benefits for him.
You're covering for health and welfare for the qualified period guys who are laid off and go to work in non-union mills.
Right.
And to rub salt in the wound, something I know for myself, they take with them their expensive leather aprons and their boots and their fancy gloves, and you're making life safer for the worker in the non-union mill at your expense.
Exactly.
Is that true?
It's true, and it's wrong. It's wrong. It shouldn't be that way.
Well, you got to plead guilty. You got yourself in the mess in the first place, because I remember last week, correct me if I'm wrong, or the week before last, on the Green River Scott thing, when it became official and the union told the region that they were operating unofficially at 263. Is it not a fact that you had to side with the IWA and say, this is a breach of the contract, live up to the contract?
Legally, technically, what those operators were doing was contrary to the labor code. And I had to tell our people that it was contrary to the law. Now, I support them 100%, morally, ethically, and any other way that we can. The rates should be rolled back. They have to be rolled back. We're talking about the survival of these operators.
Yeah, I know,
it has to be rolled back.
I'm making the esoteric point is that here is FIR and the IWA saying to an operator who's trying to stay alive, if we accept all that say, you're breaking the contract. You've got to cease and desist because you're intimidating your employees, right?
Well, I didn't say they'd intimidated their employees. What I said was that you cannot pay the 1981 contract rates, even though you have an agreement with your mill crew. You can't pay them unless you get an agreement from the local union to do that. The local union is the official bargaining agent, and you can't make deals with the crew.
You were quite happy there, or rather Clark was quite happy there for when the plant committee signed the informal agreement to work at the lesser rate, but when it came from the union to the local to the region, you were all dead.
That's right.
When it became public.
The local union was aware of the agreements that were made at those various mills, and they turned a blind eye. They said, look, if there are no grievances, we won't bother you. Go ahead. Then the region got involved in it because there were some other mill operators that wanted the same deal that couldn't get them, and the region said we have to put a stop to all of this.
As a matter of fact, this is worthwhile listening to. You see, you had Green River and Scott up here, you see, and they had this little informal deal going at the 1981 hourly rate, although they were still making their $170 a day, right?
Yeah, that was the 1981 piecework rate.
Sorry, piecework rate.
Right.
But meanwhile, Bestwood down the road, which is paying the full rate, hears about this and writes the IWA and said, hey, we're going to cut our rates too. And that's when it hit the fan.
That's right. That local union refused to turn a blind eye to it and said there is no way. And they went to the region and asked the regional council to put a stop to what was going on in the valley. As a result, we were in front of the Labor Relations Board, and knowing that they didn't have the technical legal right to do what they were doing, we had to tell the companies they had to stop it. And for that, it meant to them that they had to close down. No longer could they operate economically.
We're talking about 2, 3, or in good time, 4,000 jobs in the Fraser Valley. Good jobs, $170 a day, $3,500 a month after the break. There's nothing simple in forest-industrial relations, but this is a different program than when I had Monroe on. Not one of those words has been used. You're letting the industry down.
No, I may be letting Jack Monroe down, but I'm not letting the industry
Not letting
down.
the industry down. Now, let's take a broad look at the industry. How many piecework situations are there in the coast or the interior lumber industry in British Columbia?
There's only one now, Jack, and that is in the shake and shingle industry.
What about piecework for fallers? That's gone.
1972, we negotiated a day rate formula with the union to take away the piecework system from falling.
You would rather have had piecework.
Well, no. The quality of the work in falling was deteriorating because the fallers were being rewarded strictly on quantity. And as a consequence, we're not manufacturing logs to the standards that we wanted. We're better off on a day rate. Some people will argue with this, but we believe on the average we're better off on a day rate in falling.
Now, what's the case, therefore, to deregulate piecework in the shingle industry?
You cannot deregulate piecework. You have got to have a piecework system in the shake and shingle industry. It's a good piecework system because it reflects, or the sawyers are rewarded for both quality and quantity. And it's a good system. It works. If you took the piecework system out of the shake and shingle industry, you wouldn't have a shake and shingle industry.
But you know what they were saying about Green River and Scott. The production at Green River, which was the willingly unionized mill, was much better than was less than the production at Scott, which was a non-union, became union mill, because they would get the better logs, the better equipment, and ipso facto a better output, and could make more money at $2.30 an hour than they could over here at $2.63.
I don't believe, Jack, that they were getting better logs. They had newer equipment, but the equipment was basically the same. It's a new mill. Scott Cedar is a new mill, and it's a very good-looking shake and shingle mill, best I've seen.
Why can't you come to
the equipment is the same.
Even though Monroe will bust a gut, why can't you come to a simple compromise that was already operating informally, whereby the plant committee agreed to run for the 263, the 1981 rates, and then when the market goes up, pay them back the money they owed?
Well, the problem with that, Jack, is that you're selling at today's market at a cost that is not the real cost. Your real cost if you have to pay the money back, is at the $3.03 rate. Now, all you're doing is looking after cash flow in that situation. You're not getting a reduction in the labor cost of your square of shakes or square of shingles, and that's what has to happen. And it has to happen, or there won't be. There will not be one unionized shake and shingle operator in the valley within 5 or 6 years, unless there's a major swing around in the market.
Say that again. You're saying that
I'm saying that if the IWA does not participate with us in reducing or negotiating reductions in the piecework rates, that within 5 years I have some very serious doubts if there will be any unionized shake and shingle operations in the valley.
Well, there might be 3,000 non-union people working in shacks up
Sure.
the valley who don't pay union dues.
Sure. Or in some cases, there may be some applications for decertification within the unionized mills. Now, we don't want that. We've been happy working with the union and the shake and shingle industry for years, and we've got along very well together.
Oh, come on, I remember when Sid Thompson used to say he'd let the Hunting Merit Mill stand on its foundations until it rotted to pieces.
Yeah, but just because Sid Thompson said that doesn't make it true. He wanted a hourly rated system. He wanted to get rid of piecework, and he wanted to reduce the hours of work from 8 hours a day to 6 hours a day. Now, the Americans across the line many, many years ago dropped to 6 hours a day in their shingle mills. And I don't even know whether there's one of those mills running now. They basically went out of business.
What's the state of the industry on the West Coast or in the United States on shakes and shingles?
Within the last 10 years, the number of operations in the U.S. Pacific Northwest have increased by 73%. There are 73% more operators now than there were 10 years ago. Interestingly enough, of that 73% increase, I would estimate that almost 100% of those new operations are non-union.
And what's happened to our union operations here? Gone down what percent?
The same period of time, we've gone down 27%. Now, those are official closures, dismantling of mills. There are quite a number of our member companies that have been sitting idle for years, months and years.
But when you say that there is a possibility of decertification, what do you mean by that?
Well,
Explain that to me.
I think if the mill people who want to go to work on 81 rates, if they want to go to work, and if the union maintains the position that no, you are not going to go to work unless it's on 82 rates, the alternative for them is to decertify and go to work.
Sounds like you're advocating it.
No, I'm not. Not at all. What I'm advocating is for the IWA to sit down with us, take a realistic look at this problem. And I'm sure that once they've taken a real good look at it, they'll sit down with us and work something out. They have to. They don't have any alternative.
But the shake market especially, I believe it is, goes up and down like a bleeding yo-yo, doesn't it?
Yeah, unfortunately, in the last 3 years, it's been a downhill slide.
All the way?
All the way.
Are you in a position to say to the IWA, if you did go for a negotiated variable piecework rate, that you could bring into your orbit some of these 20 non-union shacks up the valley?
Well, I don't think the IWA would have much luck in trying to organize these non-union firms right now, because those people are working, admittedly at lower rates, but they're working, and they're looking at what's happened at the unionized mills, and they're not working. The IWA would have a tough time organizing that.
Your position is quite clear. FIR wants now to reopen the contract, to renegotiate piecework rates in the shake and shingle industry.
Correct.
And if it doesn't, down the tube.
I think so.
Yes. Questions to Keith Bennett of Forest Industrial Relations after the break. For personal reasons, I must disassociate myself entirely from any attempt to reopen the IWA contract. Or Big Monroe will clout me and say, well, if we tried to reopen the contract and that kind of thing, Bennett would sneer at us, right?
But that's just the point. That's right. But the point is that in the past, in the mid-'70s, early in mid-'70s, that we didn't reopen the contract for them. But what used to happen is these piece workers would see the price of shakes or shingles go up, and they'd start to wobble the plant. They'd go on a slowdown, or they'd walk off the job, and they'd say, we want more money. and the operator was in a good market, said, all right, you've got more money. That's happened in the past. We're saying it's time for the reverse to take
You're
place.
trying to wobble it the other way now.
Right.
And saying if you don't wobble with us, you'll lose all your jobs.
We're trying to do it legally and properly.
What? Not in places like Canfor, though. Not the whole industry.
Sure. Well, you can't treat just a few operators and say, we're going to give you a break. It's got to be right across the board to all
Well, the now
operators.
celebrated Peter King and the celebrated Scotch. You want to wobble it right across the board and say, face the facts of life, you loonies.
Don't say wobble, Jack. We're not wobbling anybody. We're trying to do this in a reasonable, rational, legal way.
Up front.
Up front.
But you do object to this kind of, what was the quote you used in the paper the other day about the blind intransigence of McDermott?
That's right.
Go ahead from Mission.
Yes. Good morning, Mr. Bennett.
Good morning.
I have to agree with you 100%. I've been in this industry for I've been in this industry for about 12 years now, and I worked for Lakewood for 8, and it's been shut down since last May. This union is so ridiculous, it's sickening. You know, I used to make about $180, $190, $200 a day. And what killed our operation is that when I made that kind of money, I'd have 2 hours a day standby time. The union was so dictatorial, they wouldn't let us give up the standby time. So I'd still make my $150 a day. I mean,
what does he mean?
You people must realize that the men that work at these operations are sick to death of these unions. I'm telling you, it's ridiculous. It's absolutely ridiculous. We can't work. It's to the point now where Monroe and these dictators have just made me so mad. And if there's ever, I seen Webster the other day getting mad at or making a comment towards Bill Ritchie out there in Mission on this vote. I'll tell you something. I'm glad to see an MLA or somebody stick up to these dictators, because this is what we need around here. And I'll tell you something else. You'll never see an NDP candidate successfully run in this area, I'll tell you.
Thank you, sir. You don't have to comment on that. What I said the other day, for your information, was that Bill Ritchie goes out and conducts a phony straw poll in a certain shingle mill, and I regarded it was called a decertification vote, and I said no such way. It was a straw poll. It was a propaganda setup. May have been true enough, but it was still a propaganda setup. Go ahead, please.
Good morning, Jack. I was just wondering why it's always the worker who seems to be in the bad end of things. I was wondering why the company doesn't take a profit rollback. And I also wanted to bring to light that negotiating with the companies at any time has never been as easy as your guest has suggested. Also in the non-union mills, if you'll check the injury and safety aspects of those mills, you'll find out that there are quite a few injuries in those mills, and that without the unions, there would be an injury rate so high that you would just about give your life. Now,
Okay, 2 questions. One, a profit rollback.
There are no profits. That's the problem. The shake and shingle industry today, at today's rates, can't make any profit.
okay, I was just wondering also, we are required to, in any company that we go into, to give all of the information on ourselves and what we're making to the company, yet the company, in return, is not required to open their books to the union so that we can bargain in good...
You're getting a little bit esoteric. What about that during negotiations? Do you open books?
No, we don't. No, we don't.
Go ahead, please.
Yes, I would like to suggest to you that over the last several 10 to 15 years, the forestry employers councils and the SOCREDs have created a non-union environment, a union discouraging environment, which has led to this situation that we have now. I put it to you, sir, that the union or the forestry employers have got nothing less than what they deserve.
Okay.
No, I'm sorry, I can't agree with that. Our industry has worked with our unions over the years to try and develop a better relationship than what we've had in past years. We've gone on committees to them. We've taken them to the marketplace. We've studied industrial democracy with them. We've done an awful lot of work working hand in hand with the IWA, and I can't agree that we're trying to create an atmosphere that's not wholesome for unionism.
Go ahead, please.
Good morning, Jack.
Morning.
I totally agree with you when you suggested Mr. Richards that he was wobbling on his end.
Now, this is Mr. Bennett.
Sitting in your program, and coming down and saying to the workmen at those mills as a whole that if they don't take a cut, all those mills are going to shut down, including the hourly workers and everybody else. And I don't know what intimidation is. And that, to me, sits pretty goddamn close to the idea of unfair labor practices.
Okay, hold on. He's accusing you of intimidation on the program, and he used the Monroe word. But that's beside the point. What do you say to that, Dave?
No, I don't believe any intimidation's been going on, and I'm not sure under what conditions Mr. Ritchie was down at the operation. I understand he was invited by the crew to go down to the operation. The employers are not trying to intimidate their employees. Simply stated, if they cannot get a reduction in the piecework rates, those people aren't going to work. Now, that's not intimidation. That's a question of fact.
And that's the way it stays until something happens to the market.
Well, hopefully, we've had Jack Monroe and Bob Blanchard out to the Valley last Friday, and they had an opportunity to talk to some of the operators, take a look at the unionized mills, and take a look at some of the non-union mills. And I don't know. I'm convinced that we're going to be able to work this thing out, and we're going to work it out with the union. And hopefully, when I get back to the office, we'll be able to get together with Monroe and get something going.
My thanks to Keith Bennett of Forest Industrial Relations. I'll be back after the break. You never know what's going to happen on Webster. Like Vander Zalm appearing from goodness knows where this morning at our request. Tomorrow morning, all we've got penciled in on the board is the antimetric man Dom. And, yes, Maxine Gelfand is appearing tomorrow morning too. And I will certainly be here at 9 a.m. precisely.